right, so today we're talking with Briana Ortega, who is a practicing attorney in Arizona, but also licensed in Washington State. I actually contacted her because I wanted to pick her brain about the topic of non-compete clauses. Restrictive covenants is the other way of saying it. So what's the difference between restrictive covenants and non-compete clauses?
A non-compete clause is a type of restrictive covenant. So when we're using the term restrictive covenant, it's much more broad. A restrictive covenant, just think about it as a contract clause that affects somebody from moving somewhere business-wise. So that can be the employees of a company. It can be coworkers of a company or clients as well. So we have non-solicitations are part of a restrictive covenant, and that's requiring that somebody who's leaving the company doesn't take clients with them. You can also have restrictive covenants with the clients themselves saying, hey, you're not going to move to a competitor for X amount of years. So when we're talking about restrictive covenants, it's a broader term, but when people think of restrictive covenants, they're mostly thinking about non-compete clauses, which is prohibiting somebody from leaving the company to either work with a competitor or to leave and create their own company that competes with their former employer.
I would say probably the majority of those who are going to watch this are the employee who would be signing a contract that has the restrictive covenant in it. So hopefully that helps to clarify a bit, because the things that an employer might be looking for might be a little bit different than what the employee might be looking for. One thing I've noticed, this is an incredibly common topic, like on Facebook groups and just other online forums. There's also a lot of unknowns, a lot of misinformation about restrictive covenants. I don't want to take it out of order, but first, are there any states in the U.S. in which restrictive covenants are essentially not allowed?
So just starting in general, the West Coast states are pretty strict against employers, meaning that they're very employee friendly, and it's going to be really difficult in those states to enforce a non-compete clause. With physicians or anybody in medical professions, pretty much across the board are held to a stricter standard, meaning that even if you're in a state that it's a free-for-all for non-competes, right? The courts don't care. You can stop anybody from competing. Even those states will take a closer look at ones when we're looking at medical professionals. The reason for that, it's all about public policy, right? A lot of people find a doctor they trust and they're going to stick with them for a decade or more, and they don't want to affect those patients by requiring medical providers to sign those. So the most employee-friendly states are Washington and California. They are actually considered the pioneers of employee rights. So when we look at employee rights across the country, most of those laws started either in Washington or California. So they're like a testing ground for a lot of those employee rights laws. And after that, usually Oregon will tag along for those, and you'll see liberal states catch on to those more. But there are some politically conservative states as well that are still going toward the employees' rights side.
It still strikes me, though, because even though in those states, many employers will still ask their staff members to sign a restrictive covenant. So that's what I never quite understood. Is that, I don't want to say it's a scare tactic, but like, what's the meaning? If they're in a state which generally will not enforce a restrictive covenant, why do they ask employees to sign one?
There are a couple of reasons. One is sometimes the employer has locations across the United States. So they might be just handing out really form contracts that they give to all employees regardless of location. So that contract might be enforceable in one state, but not in another. But they don't want to go in and start editing contracts. They just have big general counsel off in one state saying, hey, give this to all of your employees and have them sign it. So they, even if they know that it's not enforceable, it's just the form. The second reason, though, is because, like you were saying, it is a bit of a scare tactic to make those employees believe that they are prohibited from competing, really to force your employees to keep them more loyal, even if it's not enforceable. The employee will read that clause and think that it applies to them because they don't necessarily know the law of the jurisdiction that they're in. So unfortunately, that it might be one of the reasons.
Interesting. So generally West Coast. How about middle or eastern U.S.? Any other states that are particularly employee friendly as far as that goes?
So what we're seeing is, even if not by the state, sometimes the municipalities, we're starting to see more trends with city governments making ordinances related to this. But as far as the East Coast, Delaware is a pretty employer-friendly one. They're pretty corporation-friendly just in general. Yeah. So it makes sense that they're employer-friendly. Massachusetts, though, is pretty employee friendly. So it really just depends on the state itself. The West Coast states seem to all be together, I think, because the ones actually on the coast are pretty politically liberal. The East Coast, you don't really have that. It's all over the place. So I think that's the reason it's not as informed with those states on the East.
And then even in those other states, let's say California, the very common scenario that comes up in the online groups is when someone has signed a non-compete clause. I suppose there's two. One, they're considering a job. They're being asked to sign a contract that has the non-compete. And then the other, probably the more common that I've seen, is when somebody's been at a job for a while. They've decided it's not for them, but human nature, if we're going to leave a job, we generally don't want to move across the country. They typically want to find a relatively close job. And so then they go online and they're asking colleagues, how enforceable is this? I mean, regardless of which state someone is in, pretty much advisable, if somebody has signed a non-compete, they should always seek an attorney's advice before just assuming that the non-compete is not enforceable, correct?
Correct. I would certainly advise that. The only situation, if you're ever thinking that there's a gray area, go seek an attorney. And what a lot of people don't know also is when you're an employee trying to move somewhere else, and let's say you do find that job, you think you might be competing, but you think, I'm going to risk it, right? If you go to that job, not only can you be held civilly liable, but in some states, and depending on the language in the contract, your new employer can also be held liable.
That was one of my questions that I was going to ask. Because
Right.
I've seen scenarios play out. One in which somebody says, well, my employer is offering me this. Should I tell them? Like where they're actually considering not telling the new employer about their current non-compete. So yeah, I would think especially if the new employer knows that the employee is subject to a non-compete and despite that they decide to hire them, then that can also cause problems for the new employer, correct?
Correct. And I've been in litigation representing the previous employer who had the non-compete and their employee left for another company. And we filed suit not only against the employee who left, but also their new company because we knew that they had knowledge of that non-compete and decided to hire that employee anyway.
Are you allowed to describe what was the outcome?
So that case, surprisingly, usually when that happens, the new employer just terminates the employee, right? Because it's a liability. Surprisingly, the new employer backed them up and doubled down and ended up going through litigation with that. And it did end up settling for the plaintiff. So my client, the old employer, pretty much prevailed. Not in the court. We did file a lawsuit, but we settled in a favorable settlement for them.
And this was in Arizona?
This was in Washington State.
Interesting. So Washington State is one of those states that you were mentioning tends to be more employee friendly, but still it was found in favor of the prior employer, the plaintiff, correct?
Yes. And I should clarify, you're right that Washington State is employee friendly. There are some exceptions though. One of the exceptions is if you are signing a non-compete to work for the company and you're getting a piece of ownership of the company, then the non-compete can apply. So basically, if you're going to be an owner of a company, if I want to go into business with you and you say, hey, Briana, I want you to come into this business, but I don't want you to leave and take my clients and go compete with me. I'll give you 25% ownership, but I really need you to sign this. Washington State will generally enforce that because it's not just about protecting the employee. I'm less vulnerable in that position, right, as an employee because I actually have ownership of the business. So Washington State and similar employee-friendly states, they're really trying to protect like blue-collar workers or people who have less of a bargaining power with their employer. But in that situation, I do have a bit of bargaining power, right? Because I'm a part owner of this company. So a lot of states will have those exceptions, or some states have exceptions where the non-compete is enforceable if you're making a certain amount of money because they think that you do have a little bit more power. You're not protecting a blue-collar worker, a low-income worker, a middle-class worker. You're protecting somebody who's making $500,000 a year. Then that's something that they'll go ahead and enforce.
I researched a little bit prior to talking with you, and I was struck by how much variability there is throughout the country, not just state to state, but as you just mentioned, how in some states, medical professionals or other professionals are treated differently with respect to non-competes than other workers are. So it just, again, reinforces every situation is going to be different and unique. And if somebody really needs some advice, to consult an attorney. So in a lot of the contracts, another issue that comes up a lot is what's fair so far as the duration of the non-compete and the radius from any given location. This is a big issue with many people because they go to work in one clinic, and nowadays it's very common for clinics to have multiple locations. And they have multiple locations because they're trying to make things more convenient. Well, in the process, they'll have one clinic, say, at the beach, and then they'll have another one 20 miles in, and maybe they'll have another one 10 miles to the north. And so what ends up happening is when they set a radius of so many miles from any given location, next thing you know, where that person lives, that employee who is thinking about leaving, at least on paper by contract terms, there's nowhere that they can work. So is there a general rule of thumb as far as what's fair distance from any given location? Is there any rhyme or reason to that?
Everything is very fact specific, which is why it is important to see an attorney for your specific facts. Even if we're talking about two different employees in the same jurisdiction where the same law applies, it might be a different outcome. But I know exactly what you're talking about. I've had some physicians as clients who wanted to leave, and they had me advise them on what their non-compete says, where they can leave. And their contract had a similar provision, or they were in a similar situation where there were many clinics throughout the city, and their contract very smartly said the radius applies to any clinic that you worked in the last 12 months. So that is more likely to be enforced rather than X amount of miles from any of our clinics, because if it was from any clinic, regardless if they had ever worked there, a court is going to be really looking at that closely and thinking about something that's actually reasonable. But if you limit it to clinics that you've worked in the last 12 months, then the court might find that to be reasonable and enforce that.
And that radius, that distance, it's generally like on a map, literally like a straight line. Correct?
Yeah. That's actually something that courts have considered is, are we talking about miles that you'd have to drive on the roads, or are we talking about just looking at a geographic map and looking down how far, regardless of roads? Because that's a lot further of a distance than actually having to take roads to get there. Some contracts specify what they mean and some contracts do not, which opens it up to interpretation from the courts.
In general, one of the prevailing comments when I see individuals asking for advice from others, again, online in the groups, is that, they're so hard to enforce, especially if the terms are unreasonable. So like when you were just talking about, let's say a situation where an employer has 15 locations and they have it in the contract that the employee can't work within so many miles of each given location, which would generally seem unreasonable if the employee has not worked at nearly all of those locations. Well, in that situation, the courts generally see, I don't know if this is a word, the unreasonableness of a given contract. Do they look at that and tend to throw out the entire restrictive covenant, or will they then just carve out and say, okay, this aspect of it was unreasonable? How do they generally look at that? Do they look at it as all or none?
Again, it depends on the jurisdiction. So there is something in the law called the blue pencil rule. And what the blue pencil rule is, it's a rule that basically says if a contract is unenforceable, and this applies to all kinds of contracts, not just non-competes, but if a contract is unenforceable, can the court go in and edit the contract to make it reasonable and therefore enforceable? Or, like you said, are they required to just kick the whole thing out? So that will depend jurisdiction by jurisdiction. You can find that out pretty easily by Googling your state and then blue pencil rule, and it'll let you know.
Interesting. Okay. It's actually a type of policy in which any given state or locality, they'll have set up their stance on whether or not the blue pencil rule applies.
Correct. And there's three different scenarios, really, when we're talking about the blue pencil rule. You can have a state that says, this contract is unenforceable. We will not edit the contract in any way. So the whole contract is unenforceable, or that whole clause is unenforceable.
Exactly.
You have another scenario where they say, okay, this contract's unenforceable. We are going to take our blue pencil and we're going to carve out the portions that are not enforceable and leave the remaining intact. And then you also have an interesting one. This is less followed. It's less common throughout the United States, but in the non-compete setting, let's say they find that 20 miles as a radius is unreasonable, then the court will insert a term that is reasonable and say, well, we think 10 miles is reasonable. So as the court, we are going to change the terms of the contract and say it's 10 miles because that's reasonable. That last one is pretty rare because there's just a general policy in the court system in the United States that you don't want the court essentially drafting contracts.
Rewriting out.
Right. They're rewriting contracts. So that one is less common, but all of that really falls into the blue pencil rule.
Now, that blue pencil rule, would you say the majority of states and locales are in favor or do use the blue pencil rule approach or do not? Or is it just a kind of an even mix?
It's really like half and half. I mean, it's probably not exactly 50%, but it's really all over the place.
Interesting. Let's say you're providing counsel to a potential new employee of a given clinic. What would you consider? And I know it varies, but what are some good rules of thumb? Like, for example, the radius. What's a fair radius or distance from any given location?
So if you have something that is like 5 miles, that will likely be enforceable. If you have something that says 20 miles, that's where we get into a gray area, and it'll really depend on how many doctors are in your area and in your particular practice area and how big your city is, right? So for a really large city that's like Los Angeles, let's say, not only is it dense in some areas, but it also expands out pretty far, right? So in a place like Los Angeles, 20 miles might actually be reasonable, but in a place like, let's say, Tucson, Arizona, where I am, 20 miles covers a very large chunk of the entire city. So if you're looking at the radius in your specific contract, and if you're thinking, there's no way that I could leave this company and get another job in this city.
Exactly.
And you're in a gray area where it may be unenforceable. But again, I would not recommend making that analysis and just deciding for yourself. Definitely see an attorney. And also, I've been in a position where I've had somebody who wants to leave as a client. They want to leave their employer, work for somebody else, but they have this non-compete, and it is in a gray area where you're risking being sued. And I, as an attorney, been able to contact the former employer and say, look, you're in a gray area. You don't want to go through the litigation costs of trying to enforce this where you might lose. Can we just have an agreement that you're not going to go after them for this non-compete?
Tell me about that. So let's say somebody, they haven't left yet. It's a tough one, though, because if they haven't left yet, then you, by talking to the employer, you'd be essentially announcing that they're going to.
Right. That's something that the client would need to be okay.
Yeah, exactly. Yeah. But that's an interesting approach. So you found that is an option where if somebody says, okay, look, I'm just not happy. I need to leave. One option would be to have an attorney contact the employer and just let them know, hey, this is what's up. It appears that the terms of the non-compete are unreasonable. It's up to you. We can go to court with this if you'd like, or we can just agree to not enforce that. And so if they take that and they agree that they don't want to enforce that, do you then get that in writing where they agree, like sign?
Yes. Yeah, you would always want something like that in writing, and your attorney should know what kind of writing would be required. It does depend on the state. I know I keep saying that over and over.
Yeah,
but
it's understandable.
But it's true. The laws just apply very differently across the United States. But there are some ways where you can essentially modify the contract or get a signed writing that they're waiving that provision. And a lot of contracts have a clause about waiver and saying one party can waive their ability to enforce this if they do so in writing. That's present in a contract. So in that situation, we would say, okay, we would draft something that says that you're waiving this clause. You're not going to go after them for non-compete or any other restrictive covenant. And then they sign it, and that would be a waiver. And so rely on your attorney to figure out what kind of writing you would need, because it depends on the laws in the state and the contract itself. But it's definitely something that can be done, and I've done before.
So I'm trying to think of what would motivate an employer to be so kind as to waive it.
Right.
If it's pretty clear that the terms are unreasonable and it could be a mess in court, then that could be motivation. Does money sometimes come into the mix where you employee is out?
For sure. So in one situation where I was representing somebody, the way that they were compensated, they were part owner of that company. So they were foregoing 6 months of the compensation that they would have gotten as an owner, or a year, something like that. You can negotiate that. Or there are some instances where the employee may have potential claims outside of just a non-compete. Maybe the employer breached the agreement some other way, and you can say, hey, we have this claim against you. We're willing to waive that claim if you waive your enforcement of the non-compete. So there's different ways that you can come to an agreement that way, but you're right. Some employers are not necessarily going to be willing to waive something without anything in exchange.
Would you say that in general, if the employee has concerns about other breaches of a contract, that they should fully document their concerns and have that to present to their attorney, which could then be, as you mentioned, used as motivation to encourage the employer to say, hey, okay, let's just walk away, both of us, from this? Or what type of situations? Can you think of anything? Like where you have the talk with an employer and you say, look, my client is not only wanting to leave, but has some issues that they feel they could make a claim against you. But if you're willing to waive the restrictive covenant aspect of the contract, then we're willing to just leave things be.
Typically, you can have either a breach of the employment contract with the pay that was owed to them, any ownership that was owed to them that they never got, or just general wage and hour law, minimum wage laws. And you can also have discrimination claims. But of course, the whole idea of saying, hey, this employee might have potential claims, it's not to make up claims.
Exactly. That's what I was trying to phrase it carefully.
Right. So. Not at all what I'm suggesting. It's just that sometimes that does come. Sometimes that's just the fact of the matter is that there are potential claims. And sometimes they're hard. Sometimes you don't have any potential claims and you might be able to resolve something with the employer anyway by some other means. But I'm certainly not suggesting that you pretend you have claims that you don't have.
Exactly.
But yeah, it does happen though. It does happen where you were promised certain things in the contract that never came to fruition. And so you have a potential claim against them, or maybe a wrongful termination claim. Maybe they've terminated you and now you need to find a new job and you can't because you're held to this non-compete. That's a situation that arises sometimes. But those are just a few examples of some claims that somebody might have.
Now, so far as how likely an employer would be to work with someone, I suppose just in my interpretation, when I think of a practice that would be more likely to agree to just waive the non-compete clause versus one who would want to fight it, I generally think of like big corporate, some clinics are really large corporate entities and who realistically probably have attorneys working for them. And they're also probably concerned about any precedent that I would set, allowing someone to get out of their non-compete. So would it be safe to say that generally larger corporate entities are more likely to fight as compared to a smaller private practice, or it just depends?
It's hard to say. I would tell you that those large corporations certainly have more resources that they can expend. And you're right, they are also concerned with setting that precedent. They want people to know that they take the contract seriously and they will enforce it when their rights are being violated under the contract. So that is true. Smaller practices, I see areas where a smaller practice is much more into the principle of the matter. And sometimes clients who want to assert their rights for the principle of it, they will expend any resources that they can get their hands on. I've seen that happen as well. So, I mean, I think it really depends on who the decision maker is in that practice and their personality.
We talked about how the radius or distance to a location can vary depending on the circumstances. How about the duration of a non-compete? Is there a duration that's considered reasonable?
So usually I've never seen a duration of 6 months or less that was not enforceable. 6 months all around seems to be a pretty enforceable one. A year is pretty enforceable. But once you start exceeding a year is when you get into a gray area. I will say that there are some interesting cases out there about medical providers and the type of medicine that they practice will give a framework for how much time is reasonable, what is not reasonable. So as an example, So as an example, there's a case with OBGYNs having a duration of 2 years was unreasonable because they look at how often a patient or for how long a patient will see the doctor. And they think, okay, for OBGYNs, you usually have a 1-year checkup in general, unless the patient is pregnant, then you're looking at around 10 months plus a few months of care after that. And once that patient relationship ends, and this is according to the court, I understand that many times patient relationships go on for decades, right?
Yes.
But in the court's mind, they think, okay, well, a woman will give birth to this baby, have a few months of care, and after that, the practice no longer has an interest in keeping that patient. So anything that restricts the doctor from moving to a new clinic for longer than that time, so for 2 years, would be unreasonable because the clinic does not have an interest in keeping that patient for 2 years when theoretically their care is done after about a year. So that's something that will look at the type of practice that particular medical provider does, and the court may figure what's reasonable and what's not reasonable. This is not a case, but I'm thinking in my mind, let's say a pediatrician, I think it could be argued that a clinic has a longer interest because, having a child attend appointments with the same doctor from 1 to 16, 18, there's an interest in that.
Just to clarify, it's safe to say a nurse practitioner or PA leaving a practice should never solicit patients to go join them at a new practice, correct? Obviously, some patients are going to want to follow a provider, but that should always be the patient's decision. We should never try to solicit that patient because if that becomes known, then that works against us, correct? When it comes to enforcing a non-compete.
Correct. So that will be a very big piece of evidence in the practice's favor in showing that you violated the non-compete. Depending on your contract language, you can inform the patient that you're leaving and going to a new practice. And at that point, it's up to the patient to seek you out.
Can you tell them where or which practice?
It depends on the contract language because usually we're also getting into non-solicitation territory, which is pretty common with the non-compete and the non-solicitation agreement saying, hey, you can't solicit our clients. And depending on some contracts will define what solicit means. And so depending on the contract language, solicit might mean telling them where you'll be and how you can be found. And some contract language might allow you to do that. It really just depends on the language.
Okay. I'm going to talk about a couple different scenarios and just get your input. So a new employee or potential new hire has been offered a contract that has non-compete wording in it. It sounds like there are so many variables, but is there really any advice that you would give to somebody who's being asked to sign one? Because I'm putting myself in the shoes of somebody who's eager to start this new job, and I know there will be some advice to have an attorney review it, and definitely can't go wrong with that. But I can also imagine that if we have an attorney review the contract and the non-compete language, if we want a bunch of changes, sometimes that'll turn off the potential new employer. What advice would you give to somebody who's coming to you and saying, hey, I've been offered this job. This is my contract. Would you review it?
Yeah, the first thing I would certainly advise somebody to seek an attorney if they have any questions on whether it's enforceable or not. The first thing the new hire should do, though, I think, is review the contract and consider if it's something that would actually impede your ability to work after. Because if you have a contract that says, okay, for 1 year, you cannot practice within a 5-mile radius, but you're in a pretty large city and you think 5 miles isn't that bad, and if that's something you're comfortable with, then that's fine. You wouldn't have to go through the whole motions of seeing an attorney and negotiating with your potential new employer on modifying the terms. Non-competes are not always so restrictive, right? And the employer does have an interest in making it not so restrictive because they want it to be enforceable, right? So that's the first thing, is look at the terms. And again, if you have questions about what they mean, go see an attorney. But if you're understanding that this means 5 miles for 1 year and you're thinking that will really impede me and you're comfortable signing it, then go ahead. Just because you see a non-compete doesn't mean it's the most scary thing in the world. But again, if you have questions on it, seek an attorney. If you have concerns, you can seek an attorney, or some people, depending on their background, feel comfortable enough negotiating those terms by themselves with their new employer. I will say that sometimes, just from a practical matter, we will have people who come to us, we give them advice on if they want to negotiate the terms, but we don't let their employer know that we, as their attorney, exist. I've drafted letters for clients to say, here, you can sign this, and give them to it, because once attorneys get involved, understandably, employers get spooked, right?
Exactly.
It's a litigious employee. I don't know if we want.
Yes.
So that's always a possibility too, is just getting the advice from the attorney and then following what your attorney says without having to disclose that you sought an attorney for that.
Now, something you mentioned, which I think about, let's say potential new employee offered a contract and the terms are clearly unreasonable. Is that something, I mean, there's part of me that wants to say, oh, that's good news, sign it, because then it's almost as if it's so unreasonable that it will be at best case thrown out completely, or in a worst case, they'll do what was that term? The blue pencil rule. Let's say somebody presents a contract to you that they haven't signed yet, and clearly the terms are unreasonable. Do you necessarily ask them to have those terms modified to be reasonable, or what advice do you give?
My advice is certainly not to sign the contract, even though it has an unreasonable term that can't be enforced. And the reason I say that is because, one, you never know when there's a change in the law, right? There might be a later change in the law that now it is reasonable and you sign the contract. In this situation with non-competes, that's unlikely, but it's always a possibility. And the second thing is, you don't want to end up in a situation where even if it's unreasonable, you're getting sued anyway. So I always tell clients, no matter what you do, you can never stop somebody from filing a lawsuit against you. Even if that lawsuit is frivolous, you don't want to open the door to make it look like they have some kind of leverage on you. The better course of action is to not sign that contract, tell the employer this is unreasonable, and you can always find cases where that happened. I know that legal research in depth is a little difficult for somebody who doesn't have the same resources that an attorney does, but generally people can Google and find similar cases where it was unreasonable. So if they want to have that support in telling their employer that this isn't enforceable, then they can do that or seek an attorney to give some advice. So I wouldn't advise somebody to enter a contract just because they think that it's not enforceable anyway. You also have the risk that sometimes contracts function where if one clause is found to be unenforceable, then the whole contract is not enforceable. So at that point, the rights that you have under the contract might
No, that's true.
Right? So you want to make sure that when you're entering contracts that you believe it can be enforced. And if you don't think it can be, then you need to go further in negotiations and figuring out what language needs to be in there.
Yeah, it could work against them. Sure, they throw out the non-compete, but they also throw out everything else that was in your favor. Okay, so the next scenario, someone who is thinking about leaving and they have reviewed their contract and it does have a non-compete covenant in it. I can probably answer that one. You just get an attorney's advice to determine whether or not it's reasonable and would be enforceable. And then under which circumstance do you think it is safe for an attorney to contact the current employer and let them know that the client is thinking about leaving, and are they willing to waive the non-compete? It seems to me when it reaches a point at which the employee knows that they cannot continue working there, then it would be safe. Prior to that, as you were mentioning with having an attorney contact with respect to pre-employment details, it can kind of spook off the employer. Seems to me the same thing could happen. So do you ever provide advice to someone who's currently employed and currently under a non-compete agreement, but I don't know, is there anything the employee can do on their own to talk to an employer about those details? I'm thinking of somebody who's already working, already under a non-compete, but they're pretty sure they want to leave. At that stage, it's more getting an attorney to review the details and giving them their thoughts, correct?
Right. So in that situation, you're looking to leave. The best way to make sure that you are not going to have a lawsuit filed against you, regardless of whether the provision is reasonable, not reasonable, that still takes a court to decide, right? And let me tell you, litigation is overwhelming. It's very overwhelming for people, and understandably so. It's expensive. You have to hire your lawyer to represent you. So if you want to avoid that entire thing, just make sure that you are outside of the geographic region. That's the best way to do it. And unfortunately, that I've had clients who their agreement essentially said you can't practice in this city for a year. Under that circumstance where you've already signed it, the only way you can fully avoid litigation is by abiding by the terms. Start packing your bags and move. And I understand that practically speaking, people have families, they have spouses that they need to figure all this out with. Sometimes people take the year off. I've had clients to do that. They just decide to take the year off because they don't want to risk it. It really depends on how risk averse the person is. Some people say, okay, I'm just going to stay out of it and I'm going to go move to the next city over and practice there for a year. But some people are like, screw it, I want to take my chances. And people can do that too. They can take their chances. It's just up to them and how risk averse they are and what their priorities are.
I mean, I know there's no hard rule on this, but in those situations where somebody decides that they're just going to chance it, how often, what percentage of the time do you see that the employer decides that they want to make it?
I can't give an actual percentage. I will say that at least where the former employer is a smaller company, clients typically have an idea of whether they'll actually enforce it or not because they've developed a relationship with the decision maker. So if you're working for a smaller practice and you think, yeah, but the owner of this practice, while this contract is here, I know that he or she doesn't like expending resources for their practice. And again, litigation is a big resource. Or if there was a friendly relationship between the two and they developed a friendship there, then they think, okay, they probably won't because of our relationship. Sometimes people have an idea of whether somebody will actually try to enforce it, but a percentage is probably not something I could give you.
And the opposite is true, though. If it reached a point in which there was almost even animosity between an employer and an employee, then, I mean, it's safe to say that would be more likely to result in litigation.
Right. And I think it also depends on who the new employer is, too. The relationship that your old employer has with the new employer, because if they're angry competitors, then there's more motivation to actually enforce it. But if it's a small area and they want to maintain a good relationship with that other company because sometimes they help each other out, that's something else to consider. I think a lot of times people think more about the law, which is good. Think about the law behind it, but also think about the practical side of it because that can sometimes answer questions.
We touched on this earlier, but it brings up a good point. Would you say that under no circumstance, if an employee is deciding to leave and wants to go work somewhere else and is even being offered a job in a new location, but that new location may actually violate the employee's current restrictive covenant, under no circumstance should that employee not tell the new employer, correct? Because I've seen that where somebody said, well, just don't tell the new employer. As you mentioned earlier, that could cause problems. So they should always be upfront and tell the new employer that this is an issue that could come up. I mean, I don't think you would ever advise them to not tell the new employer, correct?
Right. So without telling the new employer, you might open yourself up to liability because if your old employer goes after your new employer, there may be something under the law or under your contract with the new employer that holds you liable for anything that the new employer has to pay out to the old. And I don't want to be too optimistic, but surprisingly, I have seen many occasions where the new employer is fine with it and they're willing to fight it. They're willing to, it really depends on how badly they want you as their employee. But I've seen cases where the employee in question is very successful in their field and will bring a lot of success to the new employer's business. So the new employer is willing to stick their head in and risk it and figure out what they can do to keep that new employee. But again, you don't want to hide it because that can open you up to liability based on your contract with the new employer, or in some areas of the law, depending on jurisdictions, you might have a fiduciary duty to your employer. And a fiduciary duty is essentially to make sure that you're acting in their best interest. And by not disclosing it and opening them up to liability, you might be breaching that fiduciary duty.
I think one of the final things I wanted to run by you, and I know it's still up in the air, but what can you tell me, what can you tell us about is it the FTC?
Yes.
Is it a ruling, or what can you tell me about this? Rather than me explaining what you're about to explain, you go ahead and just describe what I'm talking about.
So the Federal Trade Commission has come out with a proposal for a rule. So it's not anything that's in effect yet, but the proposal is essentially to outlaw non-competes throughout the country. And it would make it federal law, so it applies everywhere, no matter where you're located. And the interesting thing about this rule is that it's extremely broad as written right now. We talked earlier about Washington and California and how those are very employee-friendly states. this rule is more protective than those states. So this would be a very drastic change in our regulations.
What triggered that? Where did that come from?
I think it's for a couple of reasons. To be honest, when I heard it in the news, it was very surprising. I've seen a trend state by state in protecting employees and non-competes. So the upward trend makes it that it's not so much of a surprise, but I was surprised by how protective it was. So I figured a federal rule would come out that matches Washington and some of those other states, but this one's more broad and
It goes even beyond that.
It goes beyond that. And let me explain how. The way that these employee-friendly states laws function is that the agreement is not enforceable. All that means is that, well, you can't enforce it, but it doesn't mean, like we were talking about earlier, that you couldn't ask somebody to sign it. This rule would not allow employers to ask somebody to sign it.
Interesting. They're saying you can't even try to intimidate someone.
Right. So it's very protective. So you can maintain or ask somebody to sign a non-compete. So that's the first one. The second one is that there's no exceptions. In Washington state, there are exceptions where a non-compete will be enforceable. And some examples of those are if your employee is going to take a certain percentage of ownership of the business, or for business executives who are making a certain amount of money per year, you can enforce a non-compete. And the final way that the rule is more broad is that it actually requires employers who currently have a non-compete with their employees to give notice that it is no longer enforceable. So the employers really are losing a lot of their power under this proposed rule. Now, the rule is only a proposal. So whether it actually becomes enacted is a whole other question. The comment period closed at the end of April. I think it was like April 19th or somewhere around there, where anybody could comment on their thoughts on the rule. And even if it is passed as written, there's going to be a lot of legal challenges to it. There will be a lot of legal challenges on whether it's actually a valid rule. The biggest challenge that will likely come is that they've violated the Administrative Procedures Act, and they being the FTC. So the FTC is an agency. It's an administrative agency that can make rules, but only to a certain extent. They can't legislate. Only Congress can legislate. So the number one challenge that's going to come is that this rule is so far reaching that they've essentially legislated, which they do not have the power to do. They can make rules to carry out legislation, but they cannot legislate themselves. So that will probably be the biggest hurdle to overcome. So even if this does pass, we will see legal challenges to it. And, how long that takes, I don't know, but we'll see. And I don't know if it will be enacted as written right now, or if because of comments that have been made during the comment period, they'll retract a little bit. But for now, the way it's written is going to change how employee contracts look across the country.
So it is simply something that the FTC has proposed, but none of it has actually had an effect on individual states' legislation regarding the topic, correct?
Correct. So yeah, as of this recording, nothing has been enacted that would legally change anybody's position. There's a chance that general counsel of very large corporations have started amending their employee contracts just in light of what might come, or at least they're starting to edit those contracts to be prepared for it. But as of now, nobody's legal position has changed because of the FTC proposal.
Yeah, because I can see the next time somebody comments in one of the groups about their issues with the non-compete, they're wanting to leave, I can 100% see somebody commenting, the FTC just passed a law that says that they're invalid. Just to be clear, it is not in effect. Correct. If ever. And you said that there's really no way to pinpoint a timeline?
There's no way to pinpoint a timeline. Now that the comment period has closed, the agency needs to go through the redrafting process. So I don't think that we will see anything at earliest the end of the year, perhaps. And then at that point, once it is enacted, it essentially applies, but I'm sure there will be a very swift lawsuit. And under that lawsuit, a judge may order a stay on the rule, which basically says that it won't be in effect until we figure out the litigation portion of this. So we're at least a few months away until it's actually enacted.
Okay, so good to know, but no one should make any significant decisions, especially to avoid or ignore their contract restrictive covenant based on what they heard the FTC is doing.
Right.
Good. So this is probably a stupid question, but are you allowed to give advice to people who are not in Washington or Arizona? I mean, is the law pretty strict with regard to attorney counsel? Let's say somebody is in Texas or Florida and they watch this and they say, I want to get her thoughts on my contract. Are you going to be allowed to do that?
So my attorney's ethics rules allow me to provide counsel only to people in Washington state and Arizona. I can answer general legal questions, but I cannot advise you. But, I know attorneys from all over the country. So if somebody wants to contact me and ask for an employment attorney in their area, I might be able to point them in the right direction.
Perfect. So for anyone who does want to contact you and either get advice on their contract that they're currently under or potential contract, what's the best way to reach you?
The best way to reach me is probably through my website. So again, my name is Briana Ortega and my law firm is Briana Ortega Law, PLC. So you can go ahead and Google that. My website is bortegalaw.com. So that is the best way to contact me from there. It has my phone number and a little contact form if you want to do it that way.
Perfect. Right. I appreciate your help, and I'm sure you're going to get some people to contact you asking for assistance.
Well, thank you for having me. I'm a bit of an employment law nerd, which is a very weird thing to be nerdy about, but I'm always...
It's great. It's great. I'm sure it's going to come in handy for a lot of people. So, all right. Thank you.